This is a lecture from Open Tuition. For the free lecture notes that go with this podcast, please visit opentuition.com.
Page 21. You know what I'm going to ask, don't you? You know what I'm going to ask? What's the definition of a contract?
An agreement supported by consideration, made with intention to create legal relations.
Wonderful. Excellent. It's an agreement supported by consideration made with intention to create legal relations, or to be legally binding is the alternative ending. Every contract, therefore, must be supported by consideration. There is an exception. There is an exception, and that's called a specialty contract. Not a speciality. My speciality is law. But that's not what we're talking about. A specialty contract. And a specialty contract is often a deed, D-E-E-D. And so you get things like a deed of gift or a deed of covenant. A deed of gift or a deed of covenant. And those two are examples of specialty contracts. It's a promise. A deed, a promise. And a specialty contract to be enforceable, to be certain enough to be taken to court if one party breaches. For it to be enforceable by court ruling, a specialty contract does not need two-way consideration. Only one way is necessary. So if I promise to give Linda 30,000 BP shares, if I promise to give Eddie 20,000 partly paid shares in La Telecom, what did you give me in exchange? Nothing. What did you give me? Nothing. So can either, neither, or both, because they've not given me consideration, can they enforce my promise? Can they make me give 30,000 shares, 20,000 shares? Can they? Can they? She can't. She can't. She's given me nothing. Grief. She gives me grief, but she doesn't give me anything else. She gives me a headache, but nothing else. Eddie, I promised to transfer to him 20,000 partly paid shares in the telephone company. At the moment, I have an obligation to pay the rest of that capital. When the telephone company asks me, I must pay up the full value of the shares. If they're only 70 pence paid, I still owe another 30 pence per share. And now I'm giving them to Eddie. And Eddie is therefore taking from me my obligation to pay. He's relieving me of my obligation to pay another 30 pence per share. He is giving consideration, whereas you are not. So he can enforce it, and you can't. Specialty contracts, because there's only one-way consideration, because my promise to Linda is only one way, if I sign, seal, and deliver the contract, the deed document, if I sign it, I seal it, and I deliver it, then she can enforce it, even though she has given no consideration. So a specialty contract which is signed, sealed, and delivered is enforceable. But an unwritten promise about 30,000 shares, 20,000 partly paid shares, an unwritten promise, an unsigned, not sealed, not delivered, is not enforceable. So consideration is a two-way thing. It says there in page 21. It's a two-way thing, but only one way is necessary in specialty contracts or deeds. And then we have these two cases. There's no explanation as to what these cases illustrate, but in fact, these are the two cases within which the judge in the case defined what is meant by the word consideration. So these two cases, actually two definitions, which is a bit strange in itself, but there are two definitions for consideration. And it's not an unusual exam question for the examiner to say, define consideration. And then, in the context of this, explain what is meant by past consideration or executed consideration. So it's not unusual that you may find a question asking you to define. And, therefore, I have to recommend and say, it would be really good if you would learn the definitions of consideration. It would be really, really good. I was so impressed. And if you don't, and the question comes up, then we're struggling. So it would be very beneficial. And I knew when I used to teach in Manchester, I knew students in Manchester who used to have what is the equivalent now of F4. They used to have F4 parties. So they'd invite a group of them, particularly from the same firm, a group of students from the same firm, on a Friday night or a Saturday night, would go around to each other's houses, and they'd have case law parties where they threw cases at each other and asked what the case was about and what point of law. And then they used to have definition parties, and consideration would frequently come up during a definition party. So it would be very useful for you to learn these definitions. Curry and Misa. Now, I'm also going to do something else here which you do not need, and that is I'm going to give you the date of the case. You don't, big heavy emphasis, you do not need it. There are no marks for remembering years of cases. I give it to you because this other one is a 1918 case. I'm just showing you how things moved on over a period of 43 years. There's a river, isn't there? Isn't there a river? Those of you from south of here, down towards the border, isn't there a river near Bauska? Am I right? Or is it between Jekava and Kekava? I think it's between Jekava and Kekava, isn't it? Oh, sorry, Jekava and Kikava. Yeah? I think there's a river between them, isn't there? What's the river called? The River Misa. Okay, so you can remember this one. Okay, you remember Gunthing, you can remember Partridge, you can remember Misa. You've got three cases already. What was the smoking balls? What was that one? Gone? I think it's twice in your car list, isn't it? Carlil, Carbolic. Curry and Misa. Consideration is defined as. Listen, I learnt this before you were born. I've done my very best to forget it. I've tried endlessly. I've tried to forget it because it's changed my life for the worse. I feel that I am full of useless definitions like this, but I can't lose it. If you learn it, it will be with you until you've got grandchildren and great-grandchildren on your knee, and you'll be defining Curry and Misa case from 1870. You'll be defining it for your generations in the future. Learn it, please. Some right, interest, profit, or benefit. Accruing to one party or some loss, detriment, responsibility, or forbearance. Given, suffered, or undertaken by the other. Some right, interest, profit or benefit accruing to one, or some loss, detriment, responsibility or forbearance, given, suffered, or undertaken by the other. Are there any words there that you do not understand? I can see one almost certainly and the other one possible. Detriment. Bad news. Bad news from a personal point of view. Some disadvantage that I am suffering. Forbearance was the other one I didn't expect you to know. Forbearance is, if I have a right, for instance, to claim money back from Christina, she owes me money, I have the right to claim it back, I may choose to give up that right. I may choose to waive that right. And therefore I will forbear to sue her. I will resist. I will give up my entitlement. To forbear is to give up something to which you are entitled. So some right, interest, profit or benefit accruing to one party, or some loss, detriment, responsibility or forbearance given, suffered or undertaken by the other. I've got here a dictionary. We'll see what forbearance says in the dictionary. To forbear, the verb, is to cease or refrain from doing something. And forbearance, the noun, is therefore tolerance or patience. So to forbear is to cease or to give up a course of action to which I am entitled. And that's the Curry-Misa definition. And then we have another one, 1918, which is the case Dunlop and Selfridges. Selfridges is I don't know, have any or many of you been to London? The Selfridges is an enormous, very famous department store in London. And Selfridge, this is the Selfridges. Dunlop, you know what Dunlop is. We've already come across Dunlop this morning. Yeah, with tyres and the minimum amount of tread. What was the point of law that illustrated about having the 10 millimetres of tread? What was the point of law? Isn't it a presumption? Isn't it a statutory interpretation presumption that said that law shall not create an offence of absolute liability unless the Act makes it perfectly clear? An Act shall not create an offence of absolute liability unless the Act makes it perfectly clear. And so there are defences for driving whilst drunk, but there's no defence for having not enough depth in your tyres, in your Dunlop tyres. Dunlop and Selfridges, it came out through the case. It wasn't an argument about consideration, but within the case came the second judge's definition about what consideration should include. And so the judge in this case said an act of forbearance by one party, or the promise thereof, it's a strange word, or the promise thereof, is the price for which the promise of the other is given. No, it is bought. It's the price for which the promise of the other is bought. And a promise thus given for value is enforceable. Now the reason, I'll give you time to finish writing it down. Okay. All right, Benita. Okay. Now I'm not 100% certain about why we needed this. I've read about why we needed it. It's because of the situation where I'm exchanging a promise for a promise. But I don't think the Kurimisa definition failed to accept that position. The Kurimisa says some right, interest, profit or benefit. So surely an interest would be an interest in the ability to take legal action. Some right, interest, profit or benefit accruing to one party, or some loss, detriment, responsibility or forbearance. Now surely responsibility or forbearance is in fact a promise. Or detriment could be a promise. So I'm giving a promise in exchange for a promise, and I don't see, but I'm not a law expert, I don't see why Kurimisa did not cater or did not cover the situation where a promise is given in exchange for a promise received. But apparently it didn't, and therefore we have this situation. So I'm buying a promise, and I'm paying a promise in order to buy a promise. If a promise is given and a promise is received, then that is two-way consideration. It's something of value. And in fact, if heaven forbid that you cannot remember anything close to these definitions, if a question says define consideration, it comes effectively down to just a few words. Consideration is something of value. Now I wouldn't recommend that that's the best you can do, but that's what it is. It's something of value. And in a simple or a parole, P-A-R-O-L, a simple or parole contract, consideration has to move both ways. You must give me something, and in exchange, I will give you something. In a specialty contract, it's only necessary to have one-way consideration. In a question which asks for consideration, asks you to define consideration, it will typically also say, explain in the context of consideration what is meant by executed and executory and past consideration. It will often include something along those lines. I've just turned to page 24 and page 25 in your books here, page 8 in your revision kits. Page 24 and 25. Sorry, question 24 and 25. Question 24 in relation to the law of contract. Define and explain for 3 marks. For 5.4 minutes, you've got to write out Kurimisa, Dunlop Selfridges, and explain it. That's 3 marks. And for 7 marks, explain the following statements regarding consideration. Consideration must be sufficient, but it doesn't need to be adequate. And past consideration is not good consideration, which we're coming to in a minute. It's the next notes down on this page that we're on. Question 25. Define consideration as it is understood in English contract law. And then that's for 3 marks again. And then for 2, 2 and 3 we have explain and distinguish between the following: executory, executed and past. And that's a typical question 1 to 7. Absolutely typical. If you look, while we're on the same page, question 26, that's a classic question 8. 10 marks worth, blah, 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 blah. Advise Bry and Sis whether they have any rights in law to enforce Amy's promise. Absolutely classic question 8. Little scenario question, and you have to pick the bones out of it. Pick the bones out and apply your knowledge of contract law to the scenario, and then advise Bry and Chris. But for 3 marks, if it asks you to define consideration, you need to know them. You can't be sitting there thinking, what's the next word? What's the next word? Bleh, should be there. We're on to bullet point 5 on page 21, executed. I'll have a little example here. We've got Benita with her highlight pen, and I've got me with my magic pen that writes on this tablet. I want a green highlight pen, and she wants a magic pen. So we can promise, Benita, at the end of the day, I promise I'll give you this if you promise to give me that. That's executory. That's a promise in exchange for a promise. Her consideration is still to be delivered. My consideration is still to be delivered. At the other extreme, and there are 4 possibilities, because we've got she either has or she hasn't, and I either have or I either haven't. So in this situation, she's not delivered, I've not delivered. But at the other extreme, if she has delivered her pen and I've delivered mine, then both elements of consideration are executed and the contract is now complete. If I have delivered what I promised, and she has delivered what she promised, we've finished the contract. So that's executed. But there is the possibility, isn't there, that I have given her my pen, but she has not yet given me hers. So my consideration is executed, but her consideration is still executory. Or equally, I have not delivered, but she has. So mine is executory, and hers is executed. So executed says consideration has been delivered. Executory consideration is consideration which has not yet been delivered. It is a promise to deliver, but it's not yet been delivered. And that covers, I think, those 2 bullet points about executed and executory. Executed is an act in exchange for a promise. Executed is actual delivery. Executory is a promise in exchange for a promise. And then this other one, which features in both question 24 and 25 in your books, what's meant by past consideration? Because past consideration is not good. The way I was taught by a Welshman, a very thick Welsh accent, and I'm not going to attempt the Welsh accent, but he went on and on. He said, past consideration is no consideration. It's just nothing. If I have already done something in the past and it's finished and complete, I cannot use those previous acts of mine to support another new contract in the future. So if I've done something and it's ended, I cannot say, well, I did that, therefore do you promise to pay me some money? I've got to give something extra, something new in value to support this new contract. So acts done in the past are no good. They're finished, they're gone, they're ended. There was a situation I came across not long ago. The question was, have you already started repairing something? And if you have already started repairing it, or maybe a car crash, for instance. I've had a car crash, and so I'm claiming on the contract of insurance, and the insurance company says, have you had the car repaired? I said, well, yes, I have. And they say, well, it's too late then. It's already been repaired. We're not now going to pay. So that's a poor example. When I wrote these notes and presented them to John, and he said, oh, I'll pay you for those. I'll buy those notes off you. And now he's refusing to pay me. He promised to pay me £500, and he's now refusing to pay. Can I sue him? Well, yes, I can always sue him. Will I win if I do? Will I win? You can ask your friend. I phone a friend. You ask the audience. Would I win? Madara? Why? Because I've already written the notes. Before John made me his promise, the notes have been written. It's complete. If he had said, Mike, will you write course notes for F4? I will pay you £500. Then I start to write the course notes. I produce them, and now he refuses to pay. I can sue and win. But if I come here and say, John, I've written these course notes, and he says, oh, I'll pay you for those, I can't enforce that, because what I have done in exchange for his promise is already past. It's already history. I have already written the notes. If this comes up, if consideration comes up, that will be in the question. It's a standard question. If he asks consideration, he'll say, define it. What's meant by executed, executory, and past? And if you know, and it does come up, it's 10 marks. Potentially available, of which you are going to score 10, 11, 12. Past consideration is no consideration. I've got two cases there for you to help you remember. The case Re-McCardle. Re-McCardle. What is re? What's the significance of re? What's the significance of re in a case name? We had a re earlier, didn't we? What was the earlier re case? Do you remember? What was the re case? The early one? We're killing your parents, Sigsworth. Yeah. And you're right, it's where one party goes to court and asks for, what was that strange word? They're asking for this decision. What was the word? Who? I don't think so. Interlocutory. Asking for an interlocutory decision. Asking the court's advice as to what we should do correctly. And Re-McCardle, it was about a young woman and her husband, and they went to see his mother, went to visit his mother. And when they got there, the mother is living in, it looked like a bomb site. There's holes in the roof and snow and rain coming through. There's damp coming up the sides of the walls. The wallpaper is falling off. She's no wood for her fire. Her heating is down. The water pipes have burst. There are rats running around the inside of this little cottage where the mother was. And the daughter was speechless. The daughter-in-law, absolutely speechless. She couldn't believe that her husband and his brothers and sisters had allowed her mother-in-law to live like this. So they got there on the Friday and they slept in the car Friday night. They didn't want to sleep with all these rats and animals in there. And she said to her husband, listen, you go home. You've got your work to do. You've got to turn up in the office on Monday. You've got work. I will stay here. I will sort out your mother. I will do everything. So the girl stayed on. And she set about repairing the house. She knocked off all the plasterwork from the walls, got rid of all the damp, put in new damp-proof courses, new electrics and plumbing and a new bathroom suite, plastered the walls, she put wallpaper on, she painted repaired the roof and the troughing, the rainwater, the lot. And she's just finishing the last bit of painting, just the final one or two brush strokes. And she's behind the door. And the door opened, and she's behind it. And in walked her brothers and sisters-in-law. And the mother's sitting there all warm and cosy, and the fire's blazing away. And they said, "Good Lord, Mum, this is a lot better than we left you. How on earth has this happened? Who's done all this?" And this little voice from behind the door said, "It was me. It was me, actually. I paid for it all, and I did all the work." And they said, "Well, it must have cost a lot." She said, "It cost £850 to do all this." And they said, "Well, tell you what we'll do," said brothers and sisters. "What we'll do is, when the old lady dies and we sell up all her assets, out of the proceeds of sale, you will get 850, and then we'll share the rest." And the mother died intestate, so without a will. The administrator comes along, sells the assets, and starts to distribute them amongst the 6 children. And she, the daughter-in-law, said, £850 to me, and then we'll share it out 6 ways. And the administrator said, "I don't know. I need to check with the court about what I should do." So it goes to court. Does she get her 850? No. What a desperate case. Isn't that awful? She didn't get her money. Why? Because the court said, when they promised you this money, what did you give them in exchange for that promise? And she said, "Well, I painted all this wood, and I've repaired the property, I repaired the house." And the court said, "Yeah, but you'd already finished that. That's done. That's ended. You can't use that work and that expense to support a promise which you're receiving." And she got nothing. I know. I always get very emotional with that case. It's so sad. It really is a sad case. Ross Gola and Thomas, well,